1/8/2023 passed by the court of the Sessions Judge Dima Hasav Aflong in Sessions case number 22/2019, by which the appellant has been convicted under section 302 IPC and sentenced under sentence order dated 8/8/2023. Admit the appeal, call for the LCR. Ms. El Jahan accepts notice on behalf of the state. List the matter after 4 weeks.
There is an I here.
Yeah, you're right. Ms. El Jahan is granted 4 weeks time to file written objection to the IA
Lodge.
under section 389 CRPC.
I'm a blood. We drop a nine.
Mr.
AM,
A. M. Ahmed, learned counsel for the appellant. Submit that the judge impugned judgment dated 16/12/22 passed by the special judge Pokso, Bijni, Chirang, BTC. In sessions case number 110 bracket capital B slash 2018. Arising out of, convicting the appellant under section 376 and IPC and section 6 FOCSO Act
only Fox.
and consequently sentencing him under section 6 of the FOCSO Act should be set aside. Admit the appeal. Call for the LCR. Issue, Ms. El Jahan, accept notice on behalf of the state. Appellant shall take steps by submitting a scanned copy of the appeal petition to the registry of this court, who shall thereafter furnish the same to the additional PP Ms. El Jahan. The additional PP shall thereafter forward the same to the OC of the Bijni police station, who shall give the same to the victim or the guardian of the victim. A report shall thereafter be made by the OC regarding service of the said scanned copy of the appeal. List the matter after 4 weeks.
There's an
Then-
I and
There is I.
Just a minute, before that, Mr. Datta, we have said in sessions case number 110B 2018, no? Arising out of Bijni PS case number 133/2013. Because they we might not know this. Number.
yes.
They'll go by
They
this.
sometime ask for the police station case.
Once it's 30. Then in the IA, you're right, same 4 weeks granted, huh?
No
Yes.
complaints.
So again, victim has to be informed.
Lordship.
Paper book you have received,
Lordship, we will receive.
Mr.
IU Chaudhary Lordship on behalf of A. Ahmed.
Mr. I.A. Ahmed.
IU Chaudhary.
IU Chaudhary on behalf of Mr. A. Ahmed submits that. Paper book has been received. Have you received paper book, madam?
Yes,
Yes, sir.
Miss, what is your name?
A become that.
Mrs. A. Begum, additional PP. Also submits that she has received a copy of the paper book. Full stop. However, the victim / guardian has to be informed regarding the pendency of this appeal. Full stop. Accordingly, the appellant shall submit a scanned copy of the appeal to the registry.
Lordship, amicus Lordship.
Oh, yeah, the amicus.
Lordship.
Accordingly, the registry shall. Are you informed? Madam,
Remember the name, Rajesh Patnaik. Perhaps,
no, who's the case? You're the,
She's there, but then whether earlier I've sent the notice, Rajesh Patnaik, I don't remember, but maybe the registry has not given.
you see, earlier, no. No, nothing has been done.
Nothing has been. So perhaps we are yet to get our, get the copy from the registry. Or I can get it from him and he can.
He's the amicus.
Oh,
Yeah,
so
my
he is
God.
the
So registry doesn't-
Then what to do?
registry has to
registry
send me.
Send us.
Okay, then right.
Remind.
Registry to provide a scanned copy of the appeal to Miss
A Begum.
A. Begum, learned additional PP, who shall in turn forward the same to the OC of the, what police station is this?
It is lordship.
OC of the Tinsukia police station, huh? Tinsukia police station, as the case had been registered as Tinsukia PS case number 1480/18
Lordship.
under section 377 IPC read with section 10 POCSO Act, dated 8/11/2018. Full stop. The OC shall thereafter. Huh?
6%. Then.
No, the police case or the district.
6, less 10.
Yes.
6%.
Huh?
6%. Conviction was for 6%.
Conviction, maybe they're in the.
Yes.
Let us be clear about that. Then, these are this purpose. Full stop. The OC shall thereafter furnish the scanned copy of the appeal to the victim / guardian of the victim, as the conviction of the appellant under section 6 of the POCSO Act has been put to challenge in this.
One thing we have pointed out, Lordship, that your Lordship has directed the registry to provide a copy of appeal memo.
Scan copy.
But here, the Lordship, appeal memo is not there because it is a jail appeal. There I just write a letter. So that.
A scanned copy of this order.
That will do.
Huh?
That will.
This is scanned copy of this order, not appeal, huh?
That-
Oblige.
After 4 weeks.
This is a matter after 4 weeks.
Yes, the Lordship.
To enable the OC to thereafter make a report with regard to service of this. Yes,
Lordship, my senior Mr. K. Goswami has been appointed as amicus for this case. We
Yeah.
have received the paper book item if it is for.
okay,
Paper book received, Lord.
okay. It has been submitted that Mr. K. Goswami, amicus curiae, and Ms. Begum, additional PP, have received paper book accordingly in this matter for hearing in usual court.
Right.
Have you got the paper book?
Yes, Lordship. Services.
The amicus curiae is present, is absent. Miss, however, office note indicates that the amicus curiae has received copy of the paper book. Miss A. Begum, Miss A. Begum, additional PP. A big up.
A Begum, Lordship.
And additional PP. Submits that she has also received a copy of the paper. Pustak. Next para.
Notice.
Though
should be served,
notice has-
Lordship. Notice, yeah.
Huh?
Notice should be served, Lordship, because POCSO is there. Lordship. A
Already here, that direction has been made. That process should be routed through the learned APP to be served through the officer in charge.
Lordship.
So you have got to give a report. So and the office note, right? Office note dated 14/9/23 states that copy of notice has been served to the learned APP for forwarding the same to the OC of the concerned police station. For serving the notice on the father of the victim. Miss A. Begum is granted 3 weeks time,
4 weeks,
4 weeks time
4 weeks.
to obtain instructions from the concerned OC as to whether the notice has been served. This is a matter of 4 weeks.
My lord, this appeal is preferred against the conviction of the present appellant for 20 years. So along with the one IF for
Your
suspension.
father?
It's what a respondent to.
Okay,
Live streaming is not, if he does,
Informant.
the matter.
yes, so
Maybe his paper book is ready, Your Lordship.
correct. Now you give, what about the IA?
IF for suspension of sentence.
As Jahan additional PP submit that she has got no objection if the delay is controlled. Next part. On considering the grounds for the delay and keeping in view the submission made by the learned counsel for the learned addition PP, the delay of 447 days is condoned. Registry to register the appeal and this is the same after a week. Appeal and application. Huh? List, I is accordingly disposed.
Okay.
May please, my lord. Matter pertains to matrimonial appeal. We are challenging an order passed by the court below. My lord. Would kindly come to page 20.
Can in the order of the court below?
My lord, in fact, this appeal, there was a delay. And delay condoned and subsequently when the matter was listed, suddenly there was a prayer for enhancement of the maintenance amount from 6,000 to 25,000. And court had allowed it. As against that, my lord, I have filed this IF for seeking modification. My lord, in the meantime, my
You
lord,
are for whom?
I'm for the husband, my lord, who got the divorce decree. Decree is in my favor and she is now challenging the decree. So, my lord, in the
She
meantime,
now, but your maintenance has been enhanced.
enhanced to 25,000.
So are you paying that enhanced amount?
My lord, I have, as per your lordship directions, I have paid some lump sum amount now. Although, my lord, 6,000 amount we are paying regularly. But my lord, in the meantime, on last occasion, she has come out with a
Huh?
she has come out with a proposal that
There was a settlement.
yes, my lord,
yes.
20 lakhs she was saying.
20 lakhs, my lord,
My
from my.
lord, VIP, my lord, this recording is off, my lord, so that I can.
Is this, yes? Where
My lord,
is one of the,
I'm not instructed by my client that way.
Huh?
I'm not instructed by my client that way, therefore.
redo the entire exercise?
That I can do, Lordship. I am ready otherwise, but whether my learned friends are ready or not, because their case is also connected.
Because this is quite thick. Have to go through and there are three convicts here. There's no point doing it in part.
But-
We better to do it in at one go.
No, only one thing, Lordship, I highly appreciate that. My learned friend is there to represent the state. If she can show that any material is there, I am not on entire material, Lordship. Let her place her case that there is one single material that it is said the appellant is connected with the crime. Apart from the confession before police, I have nothing to say, Lordship. That
Whose confession? Molo.
accused Molodas.
Molo.
That also not to mine, my confession is also not there.
No, things has to be seen in details, but prima facie, what I find is
these person got the information that it was Molodas who hired the vehicle. The deceased family members got the information from the car stand, from the taxi stand. Thereafter, they got the police was not in the picture then. Thereafter, they got the information that Molodas is somewhere in Dimapur. Then they went to Dimapur along with friends. They caught the Molodas from that place and they questioned. And then Molodas answered. Now, of course, I'll have to see the records in a more detailed manner, but it seems before police arrived at the place where they have caught the accused, the main accused had already told them that he, along with others, had hired, took the vehicle, sold it in Arunachal, and then
Accused, who do you mean the accused?
the
Molodas?
Molodas. So police perhaps was not there. Police was thereafter informed. It is in the statement of PW1. Police was thereafter informed. Then police took him to the police station. There Molodas said that I can show the body. And then they took the police to, I think Shillong, to the particular place where the body was recovered. Arunachal Pradesh threw in the river of
Who took?
Molodas.
Molodas. Only
It was
Molodas.
entirely by Molodas, but Molodas said before other relatives of the deceased that he was with the other persons.
No, it is probably.
This is,
in
let
my-
me
in
finish,
my-
he can reply. And after 2 months, 17 days, body was recovered and it was recognized by the family members by seeing his clothes. Thereafter, PW 3, he is the brother of the victim, son of the informant, another son. He also said similar statement. He said that Molodas told him that others were present at the time of occurrence. He stated that applicant was present in the vehicle when his brother was killed. So when these
Others were
statements,
present.
others means the applicant as well as the other two persons.
Were present when the
The
person was killed.
vehicle was hired.
Who has said that?
Molodas, the brother of the victim.
How
He-
did the brother
He,
of the
he
victim?
spoke to Molodas over telephone. And then it was stated to him.
Acha, Molodas told him.
Molodas told him. And PW9 also, Molodas told him. Now, whether police was present at the time of occurrence, that we will have to see. But prima facie, it seems
But for that,
that
the matter was earlier adjourned, today it was.
Molodas,
But the problem is, we are not machines. We have got very weak
For another date, I have nothing to say. Lordship.
memories.
But let her clarify that, sir, because Lordship, whatever she said, it is contrary to record, just with due respect to my friend.
That, see,
That's
so-
what
because
I'm
of the
saying. I
PW
want
so-
to
so-
see it.
so that is what, you see, that is what. Now we have got to go through the entire gamut of documents, take one, and there are 3 of you.
No, Lordship,
So that is why-
and also in the paragraph 47, the.
Now you are, what did you say just now? You said that her submissions are contrary to the records.
Lordship.
Now we have to go through the records to see whether it's contrary or
Only
not.
the aspect of PW1 Lordship may kindly see, because the evidence of PW1 clearly says nowhere my name is there. When Molodas was apprehended by the relative. And other witnesses which they said before the police.
You see, your entire argument now
Lordship,
will be the same argument at the time of final hearing.
Lordship.
Then why do the exercise
No,
twice? Let
because
us
here
dispose
Lordship,
of-
other two appellants are also there. If they are ready, I am today ready to argue today itself. Lordship.
we are ready also.
Lordship. Because, but the problem is the other councils are there. If the Lordship fix for another date, then they will go and it will go on. Lordship. Problem is there. Lordship. Otherwise, I can argue that even today itself. Because here from the evidence of.
We'll fix a date.
Lordship, in that case, my IMAB kept pending because.
Yes,
of the-
yes. pending.
Because Lordship, there are other councils are there. If they do not press Lordship, then I have to press IA.
No, we'll have a final decision on the attack.
And
Because
IMAB
things
kept
are little
pending. Lordship.
confusing.
Huh?
Things are little confusing. PW one said that the Moloda said. he was-
You see page for para 47.
Para 47. Yes,
the
para
judgment.
47 of judgment, I have seen. There even Learned Trial Court has drawn inference from the 161 statement. That cannot be. It is a statement of co-accused and that cannot be taken into consideration, Lordship. That is
Okay,
what
anyway.
I was placing before your Lordship.
Okay, right. Uh, so everyone is ready?
No,
So when do you want?
next week. Next week perhaps it will be difficult because it will be motion days. I
Yes.
think.
Okay, right. On the prayer of the parties, list the matter for hearing.
November 9th or 10th or anything.
9th, Thursday, 9th will be hearing day, Lordship.
9th,
Nine
I
and-
think we had
huh?
we had fixed few matters yesterday, 9th.
Oh, we have
Then 14th,
14th
14.
14th of November.
of light. Yes, Your Lordship.
Yes,
Madam, this is a criminal appeal, madam, but essentially it's the bail application, madam.
yes.
In a case raised under NIA, madam, wherein my bail was rejected, madam, so I've come up before your lordship, madam. Well, before going with the matter, madam, I'd just like to point out first one more aspect, madam. Another matter arising out of the same case diary, madam, is coming on the 13, on 13, madam. So will it be heard together or separate?
Depends upon you all. We all want to, we are ready. You want to hear it today, we'll hear it today. You want to hear it that day, we'll hear it that day.
No, I'm just pointing it out, madam.
Yes.
So that
Where, only thing is that probably this case will be a torch bearer for the other case.
no, that is a much better place case, madam, because that was a student leader who has been, Yeah.
If it's arising out of the same case.
yes, madam.
So I don't know, it depends upon you. I leave it entirely to you.
But because in one exercise, your lordship can look into the diary.
That
and
can
all.
be done also.
That's why I pointed it out.
Whatever.
Then let it come out the 15 minutes.
No, I do not know what.
Otherwise, I'm also reading. madam.
I am,
doing it
twice. Huh?
Instead
the only
of
thing is that you can give us a broad idea what is the case
My lord,
about.
in this case, my lord, grenade was locked, my lord, wherein 13% got injured in the heart of the city, my lord.
Grenade was locked.
Yes, grenade was locked. No person died, my lord. 13% were injured. And till now, my lord, actually, the charge sheet has been submitted, my lord. I am accused in this case for harboring the alpha terrorist, my lord. The person who is allegedly involved in the main occurrence, my lord. I'm in the outer conspiracy, my lord, that I harbored him, kept him, and gave him shelter, my lord. And our case is that to that effect that he is a known acquaintance to the family member. He always used to frequently visit. We never harbored him, my lord. And I am behind the bus for the last 4 years. 4 years, approx 4 years, 5 months to be precise, my lord. And I'm behind the bus. And only 16 PWs have been examined out of the 250.
When did the incident take place?
The list of this one, yeah, ma'am. Well, I prepared a list of this.
15-5
15-5, my lord.
Just a few years back.
My lord,
Zoo Road, if you
Zoo Road, my lord, Central Mall,
front of that mall.
near the Zoo, my lord. It was registered by a local police pilot of Vitanagar PS, my lord. Subsequently, seeing the gravity of the thing of the situation, my lord, it was transferred to the NIA, who filed an FIR and re-registered that case on 26/6/19, my lord. Then on 11/11, charge sheet was filed, my lord, 2019, my lord, and accordingly the trial commenced, my lord. Till today, my lord, out of the 200 listed 50 witnesses, my lord, only 50, my lord.
250.
Yes. Exactly. Huh? Mala, I'm sorry, Mala, it's 157 and 300 Odds, listed documents, my lord. Exactly. And in the meantime, my lord, in this case, my lord, there are to be precise, my lord, 148, not 250, 150, my lord. 148 PWs, my lord, and
148, you said 57?
no, my lord. Supplementary charge sheet is also there. Suppose we can total it up, my lord. Number there. And in the meantime, my lord, in this case, my lord, two persons who are not directly connected with the offense were also allowed to go on bail, my lord, by this honorable court, my lord, that is A6 and A8, my lord. Amrit Vallabh Goswami and Prakash Rajkumar. Statement. Never. 177. Documents one I take even. My contention is that my lord will try to.
Yes.
So, my lord, in this case, my lord, the proposition as laid down by the Honorable Supreme Court and other courts, my lord, when a sufficient period of incarnation is there, my lord, then that may be taken into a ground, my lord, while taking up the bail application of a person. Well, in this case, my lord, I would like to rely on the judgment passed by this division branch also in the case of case to another point. If you put from it is a 147 page. The end of what? Because there are two files, my lord, we have all kept separately, my lord, in the other case. That's why I said, my lord, it may be taken up together so that I
No
can.
problem, we'll take it up together.
That will be better proportion, because one part is in my this file and the other is in that file, my lord.
Okay, right. On the prayer for adjournment made by Mr. Z. Kamal, learned senior counsel. It is not objected to by Mr. R. K. D. Chowdhury, learned DSGI. List the matter
Day after tomorrow.
on 13th.
On 13, my lord.
My pleasure, your lordship. Yes. Now for hearing paper book is ready.
Okay.
And it came earlier also, but due to paucity of time, we could not, lordship, do it. So here,
What
lordship-
about so there was no appeal filed by the co-accused,
No appeal filed by Patel lordship?
by the co-accused,
No, here is
co-convict?
no co-accused, here he is the sole accused. lordship.
No, there is.
No, the other.
That
other- no,
Rinush Basumatare.
no, I have no information, lordship, I think.
No, you see, there is an order passed on 1/8/2023. Let us see the
Absolutely.
impugned order. Impugned judgment,
Impugned judgment, lordship will find
page 61.
page 61. 61. Your lordship is absolutely correct. I recollect now.
Yes,
There was an order
there
by
is-
this honorable court
yes,
to check whether any appeal has
Status.
been filed by the
yes,
co-accused.
yes.
But I could
Ah.
not find lordship any such.
It can be found out in the website. Renew.
We had asked the registry
Uh-huh.
to give a status report
Mm,
with regard to the same.
acha.
So it says here, in view of the fact that an appeal may have been filed by the co-convict Rinush Basumatari
May have.
and disposed of by the appellate court, we are of the view that a report may be made by the registry
Hmm.
as to whether the co-convict Rinush Basumatari has filed an appeal
Hmm.
against the judgment dated so and so. If any appeal has been filed by so and so before this court, the status of the same may be stated in the report. So that has not come.
But that
Lordship, so
report
far,
is not
if I
there.
may kindly suggest one line.
Yes,
We try to take an instruction from the appellant, this present appellant,
yes.
who is languishing in jail, in central jail, district jail at Udalguri. So as per his instruction, lordship, nobody has approved. With these two co-accused, there's
No,
no,
that
because they are now in. the-
he's not, he doesn't know what the goings on
Yeah,
of this
no,
registry.
They are lodged in the same jail.
Maybe,
So.
but
that
then
is-
we have got to be sure.
That I leave it up to your lordship. But now
Because this
lordship,
order has been passed by us on 1 August, 1st August.
now lordship, he is 991 days, he is there. And his health condition is not so. good.
RINUSH. RINUSH Basumatari,
Rinush Bashmatan,
Rinush.
accused number 2. And from Rinush Bashmatan lordship, in fact, the recovery has been made. Not from me.
In fact, Pradeep Jha, it is alleged that he has to go down there at his
No, no.
place.
That is,
At a place where
There
the,
is-
Who has to go down?
and we have, it's not a go down, it's a kind of a
it's a
laboratory.
septic tank, lordship, it is said that a septic tank, it has been alleged by prosecution that septic tank has been constructed by the present appellant, but there is no connecting evidence to that. No connecting evidence.
Because
People.
no record. Otherwise, he is also sentenced to 15 years.
No, but he is sentenced to 15 years under different section. And
Ah.
I am under 27, lordship.
No.
22. Same thing.
No, under both the convicted under 20B
20B.
and accordingly sentenced him
correct.
to 15
Correct.
and 25 arms.
No, why shouldn't he appear also? Why should that person appear also?
Lordship. And that is up to him, lordship.
No, I'm just thinking because the thing is that I don't want
I
two
appreciate-
different viewpoints coming out.
I
of the
appreciate the
same
concern of
transaction.
this honorable court. I appreciate lordship.
Only we had made this observation and this report was required only to
Hmm.
ensure that there is no, different
Conflicting,
orders there.
Conflicting judgment by this honorable. But you only, what I am submitting before lordship, that the present health condition of the appellant is not so good.
How old is he?
He is 65 years old and there are records in this honorable court itself that he were allowed to go on interim bail by this honorable court on medical grounds.
He was
A
allowed-
number of
Now-
times. he
Number
was
of time
allowed.
and number of time he has surrendered. And now lordship, his health condition is, he is highly diabetic. And his eyesights are also very poor.
How old is he?
65, 66 years old. He is not that old, but because of his ailments, he is suffering a lot. The lordship knows.
But there is no application.
No, it's.
No, there were so
Yes.
many, and that was the last one.
Yes, yes. There are many lordship. Many, in fact, on the last occasion also, we have filed an application for allowing him to go on bail on medical ground, which was
So,
written.
so basically your case is that the ganja which was stored in that storage place
Lordship,
does not belong to you.
if I just submit in a one line only, lordship. Prosecution has in the seizure memo from which the seizure has been done, lordship. There were two persons, one Gaira Basumantari, one Lila Basumantari. These were the two witnesses. And very interestingly, why I'm starting from that, lordship. These two witnesses were not traceable when the trial was going on. And there's a report of the EO, executing officer, that the address where these two witnesses were staying, as mentioned in the seizure list, lordship, they were not found there. So this itself cast a doubt upon the very seizure itself. Seizure is the main thing, is the basis.
No,
So
no.
there, from there, the entire case starts. Now, lordship will kindly see. They say, I'm just giving a overlook to the honorable court. They say that the appellant has led the party to the place from where the recovery has been done. So they are trying to rope me under 27 of the Evidence Act, leading to discovery. Now, lordship, leading to discovery, as a lordship knows, there are certain limits. Number one, it has to be voluntary. Number one. Number two, there has to be some complaint. Some complaint. In this case, there was no complaint. Secondly, it was involuntary. Why, lordship, I'm saying? From his 313 statement, the appellant has said that I have taken them to a different place. To a different place where I carry out my shop. He is a businessman now. Police in the roundabout forcefully took him there. And another interesting aspect of this case, lordship, can we see, the tip-up were given by NCB, the lordship, Narcotics Control Bureau. Narcotics Control Bureau finally did not participate anyway. They handed it over to the Udalguri PS. And NCB personnel, lordship, I should not say, if your lordship take a look into their evidence casts a lot of doubt into the prosecution case altogether. They do not know what has been seized, where it has been seized, from which place it has been seized. NCB are quite professional in this regard. So that cast a doubt upon the entire case of the prosecution. Secondly, lordship will kindly see this Rinush Basumantari, or the person from whose house it has been recovered. Lordship, suppose somebody is doing something in my house. Let us take a human conduct. In my house, somebody is digging a septic tank or whatever it is. Will I not be aware, lordship? I'll be aware. Now, they have not examined the owner of this house, who have known who has done it. And the wife of Rinush Basumantari, she became hostile. She said, no, I do not know. And now, if your lordship takes into
That
the septic tank,
that septic tank was made in whose land?
Rinush Basumantari is there. But that land does not belong to Rinush Basumantari.
Who does
It
belong?
belongs to his father.
His
Father
Rinush is a male.
is a male, lordship, is a male. Now, that father was never examined. Rinush's wife was examined. Then again, lordship, under 120 and 122 Evidence Act, her evidence will be hid by privileged communication during marriage. That's my submission. Lordship, she turned hostile. She said that I have no knowledge. I'm just placing the evidence before lordship. And IO very interestingly say, lordship, that he was in Udalguri for more than 1 year. And during the entire period, he has no knowledge of any antecedent regarding this Pradipta, this appellant. Now, if we take, your lordship will see total disregard of 50, 52, 41, 44.
Where's the question of 50? How many kgs was?
He was personally searched.
No, how does it matter? Nothing was seized from his body.
Nothing was
Then
seized from his body.
50 is not
Nothing.
retractable.
Nothing.
Yeah.
Nothing. So this is altogether the case, Lordship will kindly see that nothing has been recovered from me.
So basically, in a nutshell, it's saying that the go down where the ganja was recovered from does not belong to him. It's not on his land.
No, not my land.
No, it was the thing started with information given by the Narcotics Bureau people. They came and they informed, GD entry was made. Thereafter, they went and apprehended this.
Who
Pradeep
apprehended this? The NCB?
No, the police. They informed. They also went along with the police.
But they were not made witnesses.
No,
They are.
they are witnesses,
They
Lordship.
are witnesses.
But now they are contradicting their statement. They say that we have not seen any seizure. We don't know from where the seizure has been made. Even they are contradicting regarding weighing machine. Everything they are contradicting.
And they were just part of the
No,
group,
no.
but then
Is
we'll
that
see
part?
those evidence, but the fact remains that they went, they first apprehended Pradeep Jha. And then on questioning Pradeep Jha led them to the recovery of this ganja from the storage place of Renush. And then it was recovered, and this recovery part is established by other witnesses who went along with Pradeep Jha, and on his information, the things were recovered in so many bags from the storage
No,
place.
Lordship.
So that part, 27 recovery, I don't doubt, perhaps we'll have to see again. But then there are witnesses saying that he in fact led to the
No, no,
recovery.
because why I will say no. I have a reason to say. His 313 statement cannot be discarded altogether.
Like
you need-
that later
let
he
me-
did
I think
retracted that
we
is.
submit one by one. If we are really doing it, and if we are not doing it, if the honorable court wants to fix it, let a date be fixed. I'm not insisting on that. Only my prayer is this, Lordship, if a date immediately after the vacation, because considering is been having. It is a very serious. And আপনি যেখানে কথা বলছেন, already order is there.
Silent, right? It doesn't know, so we will see. when it comes. Other evidence are very less. What I have to say.
If I can just make one prayer with your Lordship. Lordship may take it as per the convenience of this honorable court, I've got nothing to say. But so far as medical treatment is concerned, Lordship may kindly direct the superintendent because he is highly diabetic, Lordship. And his condition is really very bad. So Lordship may call for a report.
That is. the
Lordship may
duty
call
of-
for a
That
report.
they will do, that they will.
That is the.
Otherwise,
duty
they have to
of-
file an application.
So who
We
will
cannot
decide?
we cannot give a blanket order.
Lordship can kindly call for a medical report, Lordship, because last
You
time,
file an application.
Lordship, last time our case was rejected.
Otherwise, let the registry give a report.
Ah,
We've already passed an order, that's what.
without compliance of the same, taking up this matter will not be fair.
Doesn't look good.
Doesn't look good.
Oh. Or let him come, let him make a report. If he can, then we can take up the matter, what is it?
In that case, Lordship, I will pray that if this matter is taken immediately after the vacation.
Because I think in his IA, the last order was no more, no further.
I was rejected, no?
I was rejected.
Because I was rejected, Lordship, because he surrendered back. And there was a medical report that at that time, his condition was little bit stable. So on that ground, the court said that further we are not inclined to. If at all situation worsen, then court said that you can come again.
That way he can file an application. if he
Yes,
wants,
that would require a fresh application, not a
Yes,
blank.
Certainly, Lordship, certainly.
So is he coming now? So are we waiting for him? Huh? You'll inform. But what will we do? We have any other matter?
This was the last one. Very less matters are listed today for hearing.
Why?
No, I don't know why the history did not list.
Today is Wednesday.
Otherwise, Lordship, the evidences are not so long in this case.
Oh, very short and
Short,
of
short
course evidences are very less against
Okay,
him.
let's presume that no appeal has been filed.
In the meantime, someone can come and report.
They're coming, I think.
Or he wants to go deeper into the matter he just
If
said.
Lordship, I will have to go deeper. Because my colleague has made some submission. I will have to go deeper. I will have to show your Lordship of the evidences.
Actually, you have to
Yes,
go to the
yes,
evidence.
yes, yes, yes.
That is,
Absolutely.
it's for hearing.
Absolutely, absolutely. So if your lordship may just take up for
It's up
the,
to him if he wants.
It depends upon, I thought you were ready. Now you're the one who's not ready.
I'm ready, lordship.
Then?
I prepared my sheet.
Then,
I'm ready, lordship.
Then
So, not
what
nothing-
is
nothing
there?
else. Okay, let us start, lordship.
we're all ready.
Logic.
Lordship may kindly take up past the paper book, page number 43, lordship. Because my case starts from there only. 43. That is the U.
Just a minute. What was the amount of ganja that
Yes,
was seized?
it is little bit high,
How much?
660 kg.
300 and
666,
600 and
660 kg, lordship.
660 kg.
660.
On which date?
Lordship, it was, the GD entry was made on, uh,
1/4.
No. yes, 1/4/2015, and it was, recovered on 2/4. That is in the midnight.
1/4/2015.
15. That is in the midnight. Your lordship will kindly see page number 1. Occurrence of the day, 1/4/15 at 9 PM. That is where they made a GD entry. That means when they got the information in the police station by the NCB. They first-
When was the seizure made?
Yes, it is in between that night. That is why I'm taking your lordship to the Caesar memo.
Anyway, 660 kg.
660 kg.
Not that much. I remember in our
Lordship has
state,
dealt with much higher.
this ganja used to come from this Manipur. And there used to be 3000 kg seizures in trucks.
Lordship has
The
already passed.
floorboards used to be double floorboard.
That's right. Has to be
And on
accurate.
top of that, there used to be, there used to be cattle.
Oh, just to
Yeah.
cover it.
Yeah, just to, and it's smelling, this excreta is there, the dung is there, everything is there. So probably they thought that no one will ply open the floor, the false floor. And out there they were. And then I remember in one case, there was a tanker. In the tanker,
That's right. Oil tankers.
Oil tanker.
They don't spare that also.
that was long time back. That
Ah.
was in the early 2000s.
That's. This is how things are. running.
Lordship may kindly come to page 112.
I remember one was, I think, 6,000 kg. only.
Huh? Hmm.
I think one was 6,000. only.
Lordship has already given some judgments where quantities are much more higher than this. I have those judgments. Please issue, Lordship.
Maybe.
Anyway, Lordship may kindly come to
And
page number
people get
113.
away, people get away because of technical flaws.
What to do?
And NDPS Act is absolutely technical.
Hmm.
We
Very
have to be very cautious while investigating those
And
things.
police, they hardly know all the
They
nitty.
don't know.
NCB, here NCB was helping police.
Here NCP was.
Helping.
No way.
That is why actually you need a lot of training, seminar,
Mm.
workshops in the state to, sensitize them
Yes.
with regard to the various sections.
Hmm.
Hardly any sections,
Yes.
maybe 40, 41, 42,
Hmm.
50,
52.
52A.
These are the operative things.
That, otherwise, what more do you want? Nothing.
Nothing.
And then maybe section 100,
Mm.
then at CRPC.
CRPC.
That's
That's
all.
all.
If you just concentrate on these sections, I mean, it will be very hard to wriggle out. But they
Yeah,
don't
of
do it.
course.
That's the problem.
Yes, they don't. do
No,
it. Yeah, no.
These few sections have to be thoroughly hammered into their head.
Hmm.
But the problem is sometimes they can use it as a tool also.
Yeah, of course, GD entry, getting authority, they going, all those things were there. Yes, yes, these are
Yes,
just outer
Lordship will
records.
kindly see page number 113. That is the season list
113.
of the paper.
I
book.
thought you said page 43 or something.
No,
like that.
I'm coming to that. But before that, I would like to take a lordship to page 113.
Page
Because
113.
Lordship was querying regarding the Caesar. That is the Caesar list, Lordship. By which the Caesar has been made. There is exhibit 5, Lordship. And it says that the seizure was done on 1/4/2015.
9:30 PM.
Yes. Correct. So their lordship will kindly find two persons seizure witness, Gaira Basumatari and Lila Basumatari. Your lordship has kindly find it, lordship.
From the house of Renu Basumat,
Yes. From the house of Renu.
as led by Pradeep Jha.
Yes, yes. That I will prove that it is not satisfying section 27. That I will satisfy your lordship. Now, lordship kindly see that two independent witness, Gaira Basumatari and Lila Basumatari,
Just a minute.
lordship.
Yes.
So far, Gaira Basmati is concerned, lordship. The address is nowhere mentioned. If I'm not wrong, lordship. Page 113, lordship.
It is mentioned in the charge sheet, but it's
Ma'am,
written not.
kindly, please.
No, you said
Let
nowhere.
me, I am on the documents now, prosecution documents. Let
No,
me,
no,
please.
this is the typed copy or what?
This
this
is
is
the
a type
exhibit,
of-
lordship.
No, no, this is a typed copy.
Anyway,
Let us see the
LCR
original
is,
copy.
LCR is on the record,
Let us see the original.
but that is not my case. I am.
No, no,
coming-
because since you have made a submission,
Lordship,
that address is not there. Let us see if the address is there in the original.
lordship.
Oh, this. I. We did. With different pages. No, this is- Exhibit, isn't this? Sorry,
Exhibit 5.
5 page 8. Eight or six? Eight or six?
Yes, it is mentioned in number 2, lordship. Both village Panbari, Nahoria.
No, no, this one, eight. Okay. Okay. This is it, five. But just different. It's not the original.
I'm sorry, lordship. Page number 114 of the paper book shows the address.
What's
Both,
the address?
yes, both of village Panbari, Nahoria. Page
Ah,
114.
both their address.
Now lordship kindly take page 43. That is the statement of the EO, Ratul Bora. Of the paper book only. I'm in the paper book. I'm still in the paper book. May I just read it, lordship?
Yes.
On 3/11/15, I was working as constable at Majbat PS. That day, on being instructed to serve summon upon Gaira Basumatari, a witness in a special NDPS 20/15, I went to his village, that is Panbari, Nohelia, mentioned in the summon. But this is very important, Lordship, kindly see. But no person by that name resided at that address. The village headman issued a certificate to that effect. So, being unable to serve the summon, I return it with a report. Exhibit A is the summon issued to the witness, Gaira Basumatari, and exhibit A by 1 is the
What witness is he?
Caesar witness, by which the
No, no,
Caesar,
who is this person who is given evidence?
he is the EO, executing officer of the summon, who was asked to serve the summon upon these two witnesses. Shall I continue, Lordship?
Yeah.
That day, in connection with the same case, I went to village Noharia under Majbat PS to serve someone up another witness, Sri Lila Basumotari. But I did not find him there. The local public could not give any information about any person by that name. The village headman gave a certificate regarding the matter. Exhibit B is the summon to the witness and B1 is my signature with the report. So both this witness in the Caesar memo, Caesar list appears to be fictitious. Prosecution document itself. So Lordship, this cast a doubt upon the Caesar itself. Now, I will take your Lordship to the FIR, because first I was showing that there is a doubt regarding Caesar. Now, after Caesar, the FIR has been lodged. That your Lordship will find in page number 4, exhibit 3, and date is the date of lodging the FIR was on 2/4/15 at 1 AM. May I just read it, Lordship? I have the honor to inform that on 1/4/15, a team of Narcotics Control Bureau Guwahati Zonal Office unit arrived at this PS and shared a written information that
No,
one
where are you reading? Page 4?
page 4, Lord.
There is no page 4 in my paper book.
Lordship.
Asha, okay, page 4 is after page 5.
Yes.
Page 4 is after page 5.
Wrongly.
Actually, page 4 has to be written as page 5 and the other has to be written as page 4. I made a mistake. There is a page 4. dated, Page FIR dated.
2/4/15, Lordship.
From where do you get this 2/4/15?
Kindly, if it is the same page, Lordship, then it is in my paper book, it is page 5, Lordship.
Oh, no.
Yours faithfully, SI Montu Kumar Dekha, Majbat PS, dated 2/4/15 at 1 PM. 1 AM, sorry.
Huh? Okay, yes. So they're. Okay.
We are sharing one paper book with your Lordship.
Ah,
If your Lordship, may-
okay, okay. Yes,
now shall I read the FIR, Lordship?
yes.
I have the honor to inform that on 1/4/15, a team of Narcotics Control Bureau Guwahati General Unit arrived at this PS and shared a written information that one Pradeep Jha of Majbat is involved in trafficking of ganja and each quantity of ganja is presently stocked at a godown at Panbari. On basis of this information today, 9 AM, a joint search operation was conducted by NCB and Udalguri Police at the suspected godown at Panbari at the house of one Samiran Basumotari. So he is the owner of that house. He has never been examined, Lordship. On being led by Sri Pradeep Jha in presence of SDPO Bhergaon, during such 30 packets of suspected ganja
Footnote.
weighing approximate 660 kg was recovered at the house. 24 packets were of 20 kg and 6 packets were 30 kg almost. The recovered suspected ganja were seized at the PO on being authorized by SDPO Bhergaon, and sample packets were prepared at PO in presence of the witness. The accused persons Pradeep Jha and Rinush were examined at the PO and arrested at the PO. As per statement of Rinush Basumotari, Pradeep Jha is financing and trafficking of ganja. So this is the allegation in the FIR. Now, after charge sheet has been filed, Lordship, charges with one head was framed, that is in page 7. I'm not going to that, I'm coming directly to the evidences. Lordship, here,
Charges under 20B2C, okay,
yes,
then.
let me to see. Then I'm starting from page number 9, Lordship, the depositions. I will be allowed to read those depositions serially, Lordship, because,
How many witnesses?
yes, Lordship, not much, 12 witnesses,
12.
Lordship.
Not much.
Not much. It's not so witnesses. I can at least complete reading it up today, Lordship. I know that, may I kindly, Lordship?
I find her quite huge.
In respect of NDP.
Don't need so many. The more they are, the more contradictions are possible.
Yes, absolutely. That is why there are contradictions. Because now the Caesar goes, Lordship, it is in the back of my mind, at least. The Caesar goes. Caesar has not been able to be proved.
According
Now
to
I read it, Lordship. According to me, Lordship. That's my submission before Lordship. I know the informant, I also know the accused Rinush. I do not know other accused. Accused Rinush, other accused is myself, Lordship. Accused Rinush is our neighbor. It has been about 7 months since the incident has taken place. Police apprehended Rinush and took him away. Police did not record my statement. At this stage, the witness has declared as hostile. Now, so far hostile evidence is concerned, I'm not going into the legality and all because the Lordship knows very well.
no, I don't know.
But I am on the procedure of declaring a witness hostile. 154, 155 of the Evidence Act starts speaking up about the procedure for declaring hostile. But here, Lordship, my submission is this, that none of these procedures has been followed. Declaring a hostile witness only because he is not saying something, that perhaps is not the procedure or the law laid down for declaring him hostile. Anyway, the prosecution now cross, Lordship. It is not a fact that it starts with suggestion. It is not a fact that I stated to the police in such terms. I was not present at my home last night. I do not know about the incident, but a few years back, Pradeep Jha of Majbat dealt in ganja by storing the same in the backside of the house, Sanjay alias Rinush. Now, Lordship, kindly see, 2 minutes before he says that he do not know the other accused. He knows Rinush, but he do not know the other accused. And this, on basis of this statement, he is being declared as hostile. And the statements, Lordship, are 161, recorded by the police. 161 statement,
This caused by prosecution.
first by police. Under 154, 150 of
Is
the
it-
evidence.
You're reading what, page 10?
I am reading page 10, Lordship. Now, Lordship, kindly see. I know, he said, I know that Rinush and others were paid for extending their help in the business. It is not a fact that I have adduced false evidence for the sake of the 2 accused persons. Now, it is crossed by the defense. We are not concerned if Rinush and Pradeep Jha are sentenced to undergo imprisonment or to pay a fine or acquitted by the court. Opinion. Whatever I deposed today in the court is true, except the hostile portion. The police did not question me. I have no personal knowledge about the incident.
Who is he? Who is this PW1?
He is just a witness, Lordship.
Witness, what witness?
Same villager, neighbor, co-villager. Co-villager of Rinush. That is why he is saying that I do not
He
know
did not see any recovery.
that. Nothing. Nobody has seen any recovery. I'm coming to that, Lordship. Then PW2, Lordship. This is another person. He is Haren coach. He is also a neighbor of accused Rinush. That is convict Rinush. My house is situated about 50 feet away from that of Rinush. On the night of occurrence, I was sleeping as I was sick. Police did not question me. Now, at this stage, he is declared a suspect. I again submit, Lordship. These are not the process to declare witness suspect. It is not a fact that I stated to the police in such terms.
No, the probably he did not answer as was expected. And so declared hostile, and that answer has not been reflected.
I agree to what a Lordship has said. Lordship knows very well that there are certain procedures.
I don't know. You tell us how the procedures to be followed.
So far, I know. No. I am not
You tell us.
saying that this is a procedure laid down anywhere.
You tell us.
154, 155 does not lay down the procedure actually to declare as a hostile. But before declaring him as a hostile, at least his attention has to be brought to the statement that has been made by him under 161.
So that has been done for
No,
PW1
it is
also.
starting with, it is not a fact.
Okay, it is not a fact. Well,
It is not a fact means it's a suggestion. Suggestion by itself is not an evidence. Anyway,
It
I'm
is the
coming to
same- it is just the manner of putting it.
Anyway.
It doesn't really come here. Doesn't make a difference.
Anyway, now let me go on with my submission, Lordship. It is not a fact that I stated to the police such terms. I know about 3 years back, a person, Pradeep Jha, by name of Majbat, ran a business of ganja by keeping and hiding the same in the backside of the house of Vinush, but I was not aware of ganja and other things being stored this time. It is not a fact that I have adduced false evidence for the sake of Vinush and Pradeep. The cross purchase, Lordship, I do not know anything about the incident. Pradeep Jha and Vinush are not related to me. Today I have deposed the truth. I am not concerned if Vinush and Pradeep Jha are sentenced to undergo imprisonment and to pay fine or acquit by the court. Now, PW3 is very important, Lordship. She is the wife of Vinush Basumatali. I know the informant. Accused Vinush is my husband. How she know the informant that I don't know. I have heard that the name of other accused is Pradeep Jha. On the night of 1/4/2015, police of Madhvat PS and army personnel came to our house. I have recognized both the accused person present in the dock today. After coming to our house, police went to the rear side of our enclosed yard. It was raining at that time. Police woke us up and brought us towards the road for talking to us. But since my 1.5-year-old child was crying, I do not go instantly with them. I went there after about 2 minutes. Police took my husband to the police station that night itself. On the following morning, we went to the PS for my husband and learned that he was arrested for possessing illegal bhang. I do not know more than this. So after this statement, she has been declared as a hostile. It is not a fact that I stated to the police in such terms. By giving us money, Pradeep Jha, who hails from Madhvat, built a concrete tank in a corner of our enclosed yardstick here about 3 years back. Pradeep Jha brought sack containing bhang by engaging people and ran its business by hiding the same in a corner of our enclosed yard. He paid my father-in-law for that. The business has been kept closed. Then around 8 p.m. yesterday, that is 1/4/15, some laborers of the Pradeep Jha brought the sack containing bhang and kept them hidden in a newly constructed tank. I know that Pradeep Jha engaged the laborers, but I do not know their names and address. After some time, on the previous night itself, police and army came to our house and took my husband and sack containing bhang. Pradeep Jha also came with the police 3 days back. My father-in-law, Samiran Basumatari, went to Gopur to pay visit to our relatives. It is not a fact that I have adduced false evidence, as one of the accused person is my husband, Rinesh, and other accused person is my relative. Cross for the accused. There is no wall on the boundary of a homestead. Anyone can enter and leave our homestead. There is a river and a field behind our house. People can enter our house through the backside also. I came to know Pradeep Jha only after the incident. This is very important, Lordship. I do not state to police in the above manner. My child is 24 months old when police came. We told them nothing. I was inside the house with my child. Police did not question me. Whatever I have deposed today is true except the hostel portion. On the day of occurrence, it was raining with wind. I did not see the village headman or any VDP member of police, as I did not climb out of our house. So she's, in fact, as her evidence, if we read, she in fact has seen nothing. Now, PW4 is the person who has given is a forensic FSL. Okay, he has given a positive report so far cannabis is concerned. That part is all right. I'm not wasting the time of the honorable court. Now, this is PW5 is important, Lordship, because he was the SDP of Belgaum, the main person, who in fact lost that. My name is Nirupam Hajarika. On 1/4/15, while I was posted as SDP of Belgaum, on that day, a team of Narcotic Control Bureau has visited Udalguri, and I have been asked by Superintendent of Police Udalguri to accompany them. Accordingly, I proceed to Madhvat PS. Narcotic Control Bureau reported us that a huge quantity of suspected ganja is kept by Pradeep Jha. On being received the information by giving Madhvat PS at 7:30 p.m., I, along with OC Madhvat PS Deepak Das, DSP P Udalguri Pranjal Bora, along with the persons of Narcotic Control Bureau, proceeded to the house of Pradeep Jha. We have took the said Pradeep Jha to the police station for interrogation. He was picked up, Lordship. He was interrogated. Then they said that they have made a recovery. He said, Pradeep confessed before me. I don't know how they are using the word confess. That has got no evidential value. And other police officers that he kept suspected ganja in his godown. Accordingly, he led us to his godown situated in Nahoria of Majbat PS. In his godown, it was found that godown is situated at a chamber looks like latrine chamber. We have found a huge quantity of suspected ganja in plastic packet. In my presence, SI of Police Montu Kumar Deka measured the said suspected ganja and kept in the sealed packet. Said SI Montu Kumar Deka also kept a sample as per the procedure of NDPS. I was present on that said operation. Now cross. I cannot recollect the exact number of the person consisted in the said Narcotics Control Bureau. Perhaps 3 to 4% were present. They reported us that they have come from their Guwahati office. I cannot recall the name of any of the said Narcotic Control Bureau officials. This really casts little bit doubt. A person has come, he was SDPO, subdivisional police officer, and he do not know.
No, he cannot
Anyway, let me
recall,
go.
he cannot recall.
Let me continue.
That is a, you see,
They have not given me any writing. And the FIR says that there was a written information. Only SP Udalguri verbally asked me to conduct the operation. In the aforesaid GDE, it is mentioned that SDP of Bhergaon, along with DSP Pranjal Bora, arrived at the police station upon information given by Narcotic Control Bureau. The same suspected ganja were kept by the accused Pradeep Jha. IO has not recorded my statement. At a time of such, we have not been accompanied by any local village man. However, at a time of such, OC Majbat called some of the neighbors of the place of occurrence. Till recovery of the contraband ganja, none of the person was arrested, but accused persons were apprehended. I, being DSP, a gazetted officer, do not feel to state the accused whether other gazetted officer or magistrate are required. We have not stated that the time is very important here. Everything has been done in the night lodge. We have not to state to the accused that whether any magistrate is required at the time of the search operation. We have not issued any written notice to the accused before search. Whatever I have deposited in my past statement as the IO, I did not record my statement at the time of confession made by the accused in the police station. Police personnel and Narcotic Control Bureau officers were there. I have not seen any writing given by the Narcotic Control Bureau officials in the record or in the case diary, but I have seen in writing on the day of occurrence. I have not recorded the information given by the Narcotic Control Bureau. I have not put signature in any of the seizure or in any proceeding during operation. Now, Lordship will kindly see PW6. He is the informant, Lordship. Montu Kumar Deka. He lost the FIR. On 1/4/2015, I was serving as SI of police at Majbat PS. At about 7 PM that day, a team of Narcotic Control Bureau came to the PS. At that time, Mr. N. Hajarika, the SDPO, Sri Deepak Das, OC Majbat PS, and other police personnel of the PS were present at Majbat police station. The NCB team informed the OC Majbat PS that a person, Pradeep Jha, by the name, kept huge quantity of suspected ganja in the storeroom of one Basunatari's house at village Naholia. Then the OC Majbat PS made GD entry number 10 dated 1/4/2015 at 7:30 PM. On the basis of that entry, Mr. N. Hajarika, SDPO of Bhergaon, Deepak Das, OC Majbat, Sri Pranjal Bora, DSP, HC 13 officials in civil dress, some police personnel of the PS, and I went to the PS of, I went to the house of Pradeep Jha situated at Majbat town. We found him at his house. As shown by accused Pradeep Jha, we went to the house of one Dinesh Basunatari by name at Naholia. Accused Jha showed us some bhang-like substance stored in a storeroom, resembling a toilet tank chamber of Dinesh Basunatari's house. SDPO Mr. N. Hajarika gave me in writing authority to seize the bhang-like substance, and after weighing the same, I weighed the suspected ganja-like substance. The total weight of the substance suspected to be bhang, which was found in 24 packets containing 20 kg each, was 660 kg. Beside those 24 packets, 6 more packets containing 30 kg of suspected ganja, each were also found. Collecting a small amount of substance from each of the packets, I prepared 30 packets with polythene. I made samples of suspected bhang, putting 20 grams in each packet and send the sample for packet to FSL. I seized the bhang-like substance. Exhibit 5 is the scissor list, and Exhibit 5/1 is my signature. Then I seized the said article in the presence of witness for weighing bhang. I seized a digital weighing machine in presence of the witnesses from the grocery shop of one Motilal Shah situated nearby. Exit 4 is the scissor list for the scissor of the said digital weighing machine. Exit 4/1 is my signature. Therein to put seal impression of latex in the sample packets. I took 2 rupee coin from my pocket, and after putting impression with that coin, I seized the same in the presence of witnesses. Exhibit 6 is the scissor list. 6/1 is my signature. After collecting the sample as per the provisions of the NDPS, I arrested the accused persons and later I myself logged an SR. Exhibit 3 is the SR. Exhibit 3/1 is my signature. Now, Lordship, kindly consider his cross. On basis of the information given by NCB, the OC Majbat PS made the GD entry. NCB informed the PS about the incident in writing. I have seen that original copy of the written information in the court today. Intelligence officer Mr. M. Sumantha gave the said in written information. I recorded his statement. NCB gave the written complaint to OC Majbat PS and later gave the same to me. SDPO Mr. N. Hajarik and OC Majbat Mr. D. Das and other police officers, the NCB party and I went to the PO. We reached the place of the occurrence about 7:45 PM. We did not take the VDP secretary of the village or any other local people with us during the operation. At the time of search, the accused person or prior to the search, I never gave any option to the accused person nor served any notice upon them, asking them whether they felt it necessary that a magistrate or a gazette officer should be present there. I myself wrote the FIR as per the dictation of the OC. The incident took place on 1/4/2015. We investigated the matter on basis of the GD entry. It was not mentioned in the SR why lodging of the SR got delayed by 1 day. I arrested the accused persons on 1/4/15. I arrested them after I had seized the article. I do not take the signature of the accused persons on the seizure list. I conduct a preliminary investigation. I wrote in the SR that the substance suspected to be bhang was recovered from Samiran Basumati's house. But I wrote in the seizure list that the said article was recovered from Rinush Basumati's house. Samiran Basumati is the father of Rinush. Bhang-like substance were recovered from the house of Rinush and Samiran. The seized articles were recovered from a tank in their house. I did not take any step against Samiran as he was not present at his house that day. The case has been based on GD entry number 10. When I prepared the sample, witnesses namely Goyaram Basumati, Lila Basumati and UA Constable Jaguram Deka were present. At that time, neither a gazetted officer nor a magistrate was present. In the seizure list, I did not take the signature of Motilal, from whom I seized the digital weighing machine. I seized the digital weighing machine in presence of witness. I did not mention in Exhibit 6 the seizure list from whom I seized the coin. On the following day of the seizure of the substance, I sent the samples to FSL through a constable. It was my successor who sent the samples. I myself took the statement of the seizure witnesses. I did not examine any revenue authority about the area of the place of occurrence. It is not a fact that since I did not seize any substance suspect to be ganja from the accused person, I could not state about the exact location. I did not give any other written information to the higher authority about the investigation that I had conducted. It is not a fact that I recorded the statement of the seizure witness only after seizing the bhang-like substance. I put seal impression on the sample with 2 rupee coin. I did not note down the information after receiving it. I have not seen the seized article in the court. I arrested the accused person on 11 PM on 1/4/15. Now, Lordship,
Who are the seizure witnesses?
that 2%.
PW?
11 again, page 113, Lordship.
What?
They were not PW because they could not be found.
They were not examined.
They were.
Acha, they were not
found.
even made witnesses.
Yes,
They were not made witnesses.
They were arraigned as witnesses in the charge sheet, but
They,
not.
They could not be
could
found.
found.
now, Lordship, one thing.
But there's one UBC who is also a witness. with
UPC?
Constable perhaps.
Anam Constable, UB, Anam.
Anam.
He is
Anam.
examined.
He's the seizure witness.
We'll look into his evidence. I'm not on that, Lordship. Lordship, kindly see, page number 24. The last 2 statements of the IO. I arrested the accused person at 11 PM on 1/4/15. 1/4/15. Now, let us just revisit the FIR for a moment of time. Occurrence of the offense of the day, 1/4/15, 9 PM. Information received 2/4/15 on 1 AM. After information received, FIR registered. So before registration FIR, how the accused arrested? Lord.
No, the GD entry was made.
And my submission is this, that they have been arrested prior to registration of a formal FIR. That is my submission. This is appearing from the IO's own statement. IO's own statement, Lord. Anyway.
So is there any
Bar.
yes, bar for being arrested prior to the registration of the case?
Lordship, my submission will be yes. Because FIR has not been formally registered. Apprehension and arrest is entirely 2 different things. They said first that I have apprehended. Their own statement are contradictory. Earlier, they said that I am apprehended. That is why I am reading the evidences very slowly. Lord.
What does the arrest memo say?
Arrest memo is not here. Let me have a look. Lord. Hello.
LCR picture.
Hello. Thank you again.
Arrest picture never part.
Hello. Hello. Nishwa ke wo vichar nahi. Arrest memo, perhaps lordship, it's not here. That may be in the record, lordship. Not here, lord. Now, lordship may kindly see. Muntu Kumar Deka. He is also, that I have read. No, yes, Muntu Kumar Deka, PW6 lordship. It is his evidence is continuing. He was, it should not be recrossed, it should be further crossed. They are writing it recross. Page 25, Lord. Before my departure to the police of place of occurrence, page 25, 25. I'm continuing, Lordship. I'm continuing.
Mantu Kumar. Mantu Kumar.
Yes. Mantu Kumar Deka, he was further cross-examined. That is, I'm reading, Lordship. Before my departure to the place of occurrence, the SDPO gave me written authority in the PS itself to seize the bhang. He gave me the said authority letter before my departure to the village. Nohua, I questioned Motilal Shah at his shop, but I recorded neither his statement nor the statement of any person, merely by name. I did not take any receipt from the Motilal after returning him the weighing machine. We went to the village Nohua at 9 p.m. Although I found the seized bhang in the place stated to be a godown, but somewhere found in the safety tank of latrine. I did not find any evidence to the effect that Pradipja used the godown. That is the place where the ganja was recovered. Very specific statement. Page 26. That is his own statement.
What does he say?
Lordship, it will be 1, 2, 3. 3, it starts from the third line. I went to the village Nohua at 9 p.m. Although I found the seized bhang in the place stated to be a godown, but same were found in the safety tank of the latrine, I did not find any evidence to the effect that Pradipja used that godown. That is the place where the ganja was recovered. So it's a very straightforward evidence also in favor of this appellant. I seized the ganja at 9:30 p.m. in connection with the GD entry number 11, dated 1/4/15, made in Majbat PS. The SDPO gave me the authority by Majbat PS GD entry number 10, dated 1/4/15. We had seized the article before. Now things are being clear, Lordship. But before any entry, they have seized it. Although I went on basis of the GD entry number 10, I showed it as GD entry number 11. We went to the house of Samiran Basumatari. After seizing the article, I did not inform the superior authority, that is SP of the district. I did not mention in the case diary with what and as what substance the ganja was packed after the seizure. I prepared the packet at the place of occurrence. I prepared 30 sample packets, but it was not mentioned where I prepared the sample packets. I have stated that I prepared the sample packets in presence of the witness. I did not mention from where and by whom I brought the 30 sealed plastic polythene bags. I started packing the sample packets at 10:10 p.m. I prepared 30 packets with the help of my staff, but I did not mention the CD who were present there. I took the statement of Vinesh Basumatari at 10:10 p.m. Vinesh Basumatari stated on that day of the occurrence, some laborers kept the materials and left the place. Pradipja did not came with those laborers. In course of the investigation, I did not try to know who the laborers were. Pradipja showed us the room. No bhang-like substance were recovered from that room. That means it is his 313th statement that earlier he took them into a different room. From there, no recovery was done because he was having a grocery shop, Lordship. This Pradipja. He is a businessman out there, Lordship. In his statement made before me, Pradipja stated that he did not own the bhang-like substance. I seized the 2 rupee coin from myself to use it as a seal. I sealed the sample packet at 11:10 p.m. The bhang-like substance were at the place of occurrence until sealed. It is not a fact that we put the bhang-like substance in a packet in 2 hours. It is not a fact that I did not record the statement of Lucky Mili, who was the witness to the seizure of the coin. Although I stated that Lucky Mili was a police constable, I did not mention his constable number in the seizure list. Although I have stated that there were independent witnesses at the place of occurrence, I did not record statement of any of them. I recorded the statement of NCB officials around 12 midnight. I took about 30 minutes to record their statement. We reached Madhvat PS within 20 to 25 minutes, and it was around 1 AM on 2/4/15. I mentioned that I wrote the SR around 1 AM on 2/4/15. It was not mentioned in the CD to whom the NCB officials had given the information. The SDPO, the OC, and the others went to Pradipja's house in the same convoy. Thereafter, our senior officials entered the bedroom of Pradipja, so I do not know what type of discussion they had with Pradipja. I recorded the statement of SDPO of Bhergaon. I did not record the statement of DSP, Probation, Pranjal Bora, or the OC. Although I mentioned in the SR that Pradipja provided finance in the business of ganja, I did not find any evidence to that effect during investigation. Although he has written, but he did not find it also. We carried out the investigation on basis of NCB's information. The number of male presence in Rinu's family was not mentioned. I do not know if he had other brothers. It is not a fact that I filed this case as per the advice of my superior officer. It is not a fact that the two witnesses shown in the seizure list are fake one. Now, Joguram Deka, the person who was present there, the only person. I know the informant. I do not know the accused person in the talk. On 1/4/15, I was serving as constable at Madhvat PS. That day, in the connection with Madhvat PS, the IO seized 2 packets of suspected ganja. Exit 5 is the said seizure list. Exit 5/1 is my signature. Therein, that day, the IO has also seized a 2 rupee coin. Exit 6 is the said seizure list. Exit 6/2 is my signature therein. Now, Lordship, kindly have a look at his cross. The IO recorded my statement. I stated in my statement that police made a search in the godown. Though I stated in the statement under 161 CRPC that articles were recorded from the godown, I did not see the godown. I do not know where the godown is situated. I do not know the owner of the godown. Though ganja was recovered in that godown, I do not know whom the said ganja belonged to. I stated to the police that I did not know whom the ganja belonged to. I do not know how many people resided in the campus in which the ganja were seized. Since I do not go to that campus, I do not know how many families resided there. My signature on exit 5 and exit 6 were taken at Madhvat PS. I do not know for what purpose the IO used the sheet of the papers on which I put my signature. I do not know how many packets were prepared. I do not know the weight of the same two. I do not know what these things were. I do not know what was seized from and whom through exhibit 6. I have been serving at Madhvat PS for about 3 years. The distance between village Mahua and Madhvat is about 9 to 10 kilometers. I do not know what was written up to exit 5 and exit 6 when I put my signature there. I do not know who seized what. I do not know the day or the date on which the ganja was seized. I do not go to the place where the ganja was recovered. So this casts a doubt into the entire recovery. Now, Lordship will kindly see here from here, the NCB's statement starts. PW 8, page 32 onwards, Lordship. He is Saurabh Samanta. The IO say that the information was received from him. I do not know the complainant. I know the accused person. On 1/4/15, how we know the accused person, he has not said. Shall I continue, Lordship? Shall I continue?
2 o'clock.
Can I make a prayer, Lordship? Can it be from 2:30? Then CBI meets. If your Lordship kindly allows from 2:30, Lord. I'll again go to Chanmari. I will come back.
Or tomorrow we can continue.
Tomorrow I'm having some personal difficulty. Today, at least, let me finish reading the depositions, Lordship, my part.
The judgments and all, yeah, perhaps we will go into that point of conscious possession and all.
Of course,
So those judgments have not got
Conscious,
perhaps-
constructive.
constructive.
there is no,
conscious or
neither
those.
conscious nor constructive.
His
Absolutely
basic case is that he has
Ah.
got nothing to do with it.
nothing. to do.
Yes.
On his only ground will be that this disclosure
Hmm.
allegedly
27.
made by him.
27, they are trying to rope me in 27. And then they have said, Lordship, they have first interrogated me in the police station. Then they have taken, and they are also saying that first where they took me, there they did not recover anything. That is in the prosecution statement itself. Subsequently, they took me there. So it was involuntary. 27, it was involuntary.
No, voluntary and all will not come in 27. Voluntary comes in
Yes.
164.
Lordship, I remember I did one case long back when I was very junior, Lordship. Even now I am junior. There, Lordship, on basis of this voluntariness of 27, I was acquitted in 302 and Arms Act. What has happened? One arm was recovered.
No, we'll see.
No,
see,
that
we'll-
is
we'll
different.
see.
Now, we'll come to that.
27 only is fact recovery. Out of the information given by him, whether it's voluntary or not, will not matter.
That
I don't know
fact
what
has to
law
be
is
voluntary.
talking of.
That
the
fact cannot be
fact-
involuntary. That fact from my mouth or from anywhere.
Then
Has
let
to
him
be
show some
voluntary.
judgment on that.
Yes,
I'm
I
not
will-
aware.
I
I'm
will
aware
certainly show.
when the fact, not even his statement and all are not admissible, only the fact. And fact is recovered from the answers given by him. Whether how he answered, how he had given those information, that will not
And
matter.
we will see.
Yes.
That will see.
That will matter, Lordship.
So,
I'll go on that.
2 o'clock, you all are not free.
2:30, Lordship. Lordship may fix some other day. Your Lordship. As per the convenience of your Lordship.
Now, why didn't you say this in the very beginning that you were not being able to continue?
No, I will continue. 2:30 if you Lordship can be allowed. Or 2, okay, fine. Try to come back with.
If he's stuck in that court. So let us then again start tomorrow morning. Oh, tomorrow. Tomorrow is Thursday. Friday morning?
It's Friday we can do.
No, Friday we have fixed that item, no, that
Ah.
Mr. Z Kamar, I think. He will say something.
Because Lordship, my
Today's matter.
Ah.
colleague is objecting like
Because
anything.
there
So-
are two,
No, but I'm not objecting. I'm
he has to give his submission also.
I leave it here,
Well, the
Lordship.
case is otherwise very small. It is only leading to discovery whether he at all had the knowledge.
Whether basically the discovery issue is the issue. That's all.
That's all.
So I will have to, Lordship, argue in that it was absolutely involuntary because it's my 313, Lordship. Why should my
We will
313
see,
be?
we will see, but then we can try 2:30. 2:30.
230, deeply only, not. PW8 in page number 32 of the paper book, Lordship.
Page
32, Lordship. Lordship, PW8 happens to be that intelligence officer of NCB who in fact gave the information. His name is Swarup Samanta. I do not know the complainant. I know the accused person. This is little bit surprising. Lordship. On 1/4/15, I came to Guwahati NCB office. From Guwahati NCB office, one Inspector Suresh Kumar and a sepoy had come to the place of occurrence as per direction of our superior officer, General Director. I have been to Guwahati and as per the direction of the Superintendent of NCB Guwahati, the Inspector Suresh Kumar and other constables were accompanied with us. At first, we met Superintendent of Police Udalguri, then cooperate with the operation. We have launched the operation on 1/4/15. The information was the accused Pradeep Jha has stocked a huge piling of ganja. He involved in interstate
she appears to be the mastermind.
from the evidences, but I will go to other
No,
evidence.
no, not from the, from, I do not know, it appears to be.
Yes, yes. Actually, what is happened, Lordship, if I just make one submission, that area, Udalguri area, there perhaps some ganja business is going on. And maybe there was some person, because why I'm saying there was, Lordship, because IO has categorically said that till when the IO was in that Majbat PS, there was no person, that this particular person was not involved in any. Maybe some person was there having a common name. Maybe, I don't know, maybe. There is every possibility. The accused Pradeep Jha has stocked a huge piling of ganja. He is involved in interstate ganja selling activities. Accordingly, I, along with the informant and other police personnel, launched an operation at the Panbari Boskabari. We have recovered some suspected ganja, which was kept in a chamber-like newly constructed toilet tank. Then police personnel has recovered the said ganja and I returned back.
What is a toilet tank? I wonder, why do they make up names?
Oh, maybe.
But I think it's a septic tank.
It must be a septic tank.
Septic tank.
And in that other case, there was a latrine tank. There's no latrine tank as far as I know. There's a latrine. It should be septic tank.
Septic tank.
Yes.
Maybe.
Yes.
Now the cross follows lordship. NCB has zonal office at Guwahati, but I am from zonal office Kolkata. Information was received from Kolkata zone, not from Guwahati. Direction was given by our zonal director verbally, but tour program was approved by our zonal director. In our tour program, our zonal director directed me to meet the zonal director Guwahati. I have not submitted the said tour program in the office of zonal director Guwahati. At the place of occurrence, our informer has shown the place.
I have not submitted the set proposal.
Now, another person figures, lordship. Informer. Informer has shown the place. So long from the police record, it was appearing that this gentleman is the intelligence officer. He is the informer. Now he is saying an informer has shown us the place. And that informer has never been examined. Lordship, may kindly have a look at it. I cannot say was the owner of the said place of occurrence where the aforesaid ganja was stored. I cannot say how much ganja was recovered and who has seized it. These things cast a doubt whether he was present there or not. I cannot say whether there was a magistrate present at the time of recovery. Similarly, I cannot say who the real owner of the contraband item is. After recovery, I have left the place. I have no knowledge about the case. Only I have shared the information. Now, another NCB personnel. That is PW9, Suresh Kumar Singh. I know the complainant. I know both the accused persons. These statements are quite surprising. How they know the accused persons?
Now.
Oh, now, okay. At the time. The incident took place on 1/4/15. Our intelligence officer Saurabh Samanta has come from Calcutta Journal Office and informant that some Pradeep Jha has dealt in some quantity of ganja. Then said Saurabh Samanta has submitted written information to our superintendent. Then we have constituted a team. Our team consisted Saurabh Samanta, myself, Sukumar Brahma, Sipoy of NCB. Then we came directly to SP Udalguri and then cooperated the operation with the help of police personnel. On the said day, we have been to Majbat at village Panbari. In that place, we have found one godown owned by Pradeep Jha. Now he is saying this godown is owned by Pradeep Jha without any supporting, without any corporation. In the said godown, ganja was kept in a chamber like water tank. During that time, there was some darkness, so I cannot say whether the tank was newly constructed or old one. But there were some packets of ganja. Then police seized the said ganja and we have returned. His cross-lodging can be considered. We have received SP office Udalguri at about 5 p.m. After
We
discussion,
have, must be reached.
wrist. I spell it wrongly, Lordship. It should be wrist, but written on receipt.
This is the original. I mean,
This is the
photocopy of the original.
Yes.
Yes.
Photocopy of the original.
Anyway, it's a typographical mistake appears to be. After discussion, we have proceeded to Majbat. At about 7 p.m., we have reached at Majbat. The secret information was originally reached at Kolkata office. Then the information was sent to our office. I cannot say who has shown the
Yes,
place
sir.
of occurrence.
The secret information was originally
They say that it was received in Calcutta office. Then it was sent to NCB Guwahati. That is what is in their deposition, Lordship.
yes.
We were shown the place of occurrence. It was rainy day. We, the NCB team and the police have entered the campus. The contraband was kept in a chamber-like water tank. As the informant has informed us that the accused kept the contraband in a godown, so I stated it as godown. We have only accompanied the police. I do not know who has stated the said contraband, but according to Majbat PS, they have seized 660 kg of contraband. On that day, we have seen some packets and those were carried by the police personnel. After the recovery of contraband, we have left the place of occurrence. We mean the team of NCB. We have been informed by the informant that Pradeep Jha is the owner of the house. Whether the contraband is owned by the accused or not, that is looked after by investigating agency. I cannot recall whether the said tank was bounded by fencing. I cannot say who is the owner of the said tank, said land, sorry, where the tank is situated. Who has authorized to seize the contraband, I do not know. I cannot say whether there was magistrate during that operation. At the time of operation, there was independent witness. It is not a fact that I do not have any knowledge about the fact. Now, the last from the NCB lordship is a sepoy, Sukumar Brahma. I do not know the complainant. I cannot recollect the exact date of the incident. On that day, we have been asked to go to a place at Udalguri. The original information was conveyed by our Kolkata office. Accordingly, Mr. Samanta from Kolkata NCB office, Suresh Kumar, myself went to Udalguri police office and consulted with the state police about the aforesaid operation. Then we proceeded to Majbat along with DSP and some police officials. We have found a place where ganja was kept in a tank-like chamber. Then the aforesaid ganja was recovered from the said tank and handed over to police personnel by Majbat. At the time of operation, accused Pradeep Jha was also there. During that time, I have not seen Renu's Basumatari at the place of occurrence. I cannot say by whom of NCB gave the information. As an officer asked me to accompany them, so I accompanied them. I cannot say who is the owner of the aforesaid ganja. The ganja was directly recovered from the said place and took to police station. I am sure that the ganja was not measured in my presence at the place of occurrence. I have
No, this is nothing, I think.
nothing. Yes. Now, lordship, let us go to the IO. Because lordship will kindly see why I am skipping PW11. PW11 simply filed the charge sheet. He did not do the investigation. He said it. That I have simply filed the charge sheet. I submitted the charge sheet against the accused. So is my signature. So his cross was declined. Nothing is said. PW12 is the main. He conducted the entire investigation. And I am relying upon his evidence, lordship. His name is Dilip Kumar Kataki. Page 40, lordship. On 2/4/15, I was in charge of Lalpani OP under Majbat PS. On that day, SI of Police Montu Kumar Deka of Majbat PS lodged a written FIR before OC of Majbat PS against accused Pradeep Jha and Renu's Basumatari, alleging that they were involved in trafficking of ganja. On the basis of the said SR, Majbat PS case number 20/15 under section 20B2C/27A of NDPS was registered. Exhibit 3 is the said FIR. I was entrusted to investigate the case. Accordingly, I visited the place of occurrence, prepared sketch map of the place of occurrence, recorded evidence of the witness under
No,
section.
this Ejahar was filed after the season.
Yes, yes, lordship. After the season. First, what they did, if I just recapitulate, first they picked me up. That is why I'm saying, lordship.
They picked you up.
Yes, they interrogated me. Then they took me to the place where they made a seizure. Then the affair was lost. Then I was arrested formally. So that is why I'm saying, lordship, that they are saying 27. 27 is not voluntary, and that I will show, lordship. And that's some citation also I'm having in this regard. PW1 Mohit Rava stated before.
Madam, have you got your arsenal?
No,
Oh.
lordship, because I think he'll also be not been able to, I think he'll not be able to complete it today.
Oh, he'll not be able to complete today.
He has some other judgments to show, that is what he said. So
Oh,
then I'll reply after he finishes.
my God. So it's going to be a 2-day affair. At the,
Tomorrow, day after, he'll not be there, he said.
17, if your lordship kindly can.
Because I'll have to show, take out those judgments on.
anyway, carry on. Since they're
Right.
nearly finished.
Right.
This is the evidence part.
Let me finish the evidence and 313, lordship. Only those part which is important, 313. PW1 Mohit Rava stated before me that yesterday night he was not at home. He knows nothing about the incident of yesterday. This is important because contradiction is not coming up, lordship. Contradictions are coming up now. But some years back, Pradeep Jha of Majbat used to deal in ganja. That is why, lordship, I am submitting maybe someone in the name of this person. Some
Maybe
years
the
back.
same person, but they were never caught.
No, I'm coming that he is not. This person himself said he is not. I'm coming to that point, lordship. And he used to store ganja in the rear side of the house for Renish while dealing in the ganja. He also stated that he had knowledge that Renish paid the helping in such act. PW3, these are all contradiction, lordship. PW3, Srimati Mila Basumati stated before me, then in the last year, Pradeep Jha of Majbat got a pakka tank constructed in the corner of her house premises around 3 years back. Pradeep Jha engaging some men kept gunny bag of the bhang in the corner house premises and used to deal in those bhang. In that connection, her father-in-law was paid. Therefore, the state business was closed. On the night of 1/4/15 at about 8 p.m., the labor of the Pradeep Jha again carried out the same gunny bag containing bhang and kept them the same concealed in the newly constructed pakka tank. I know the laborer who have been engaged by Pradeep Jha, but I do not know their name and address. Some moments thereafter in the night itself, army and police personnel appeared at our house and apprehended my husband along with the gunny bag containing bhang and took my husband. Pradeep Jha also came along with the police. My father-in-law, Samiran Basmati, went to Gopur.
Bhang is the green,
Yes,
the green one.
absolutely. I think, if I am not wrong.
It's put in the lassi during Holi,
During those years, only times.
during Holi. Because I remember in Delhi, they used to make in the hostel. The big katoris. With milk and that lassi and everything over. And then they with some dry fruits and all they used to put, I think.
That is like little religious kind of a
Yeah.
thing, but otherwise also it's available in the market for intoxication purpose, so that is.
But the green one will be, how would you use the green one? Same manner, it will be put in a drink or something.
I don't know, I have no idea.
Sorry, Lord.
No idea.
No knowledge.
But it's available in small shops on the roadside.
No, but I think this is, Bhang probably use the, not the dried one.
But Lordship, here, FSL has said that it's a
Cannabis,
ganja.
cannabis.
No, it's ganja. I'm not saying it's not ganja.
Their local name, I think they're using it as.
No, you see, because, there'll be the dried one, there'll be
Yes, yes, I
the
cannot
one
take
that is still
Root
green,
and stem cell, correct?
the still green, which has not dried up. So, a Bhang is the one which is not dried,
Absolutely. Now, Lord,
if I remember correctly, as far in the 80s.
Mhm.
so let us take the cross part, Lordship. The incident occurred on 1/4/15. PW1 in his statement recorded under 161 statement CRPC stated that he knows nothing about the incident that occurred regarding the occurrence of this case during my tenure at Madhva PS, particularly my posting. This is very important, Lordship, particularly at my posting of place of at Lalpani. I did not find any allegation against Pradeep Jha prior to this allegation. So this is the first case against him. Prior to this, there is nothing. He's a different person. That Pradeep Jha may be somebody else who escaped everything. I did not make any inquiry with PW3 as to when she got married with Renush Basmati. I recorded the statement of
Why, where are you reading? Okay.
cross partnership.
Yes. I did not make,
I did not make any inquiry with PW3. PW3 was the wife of Renush Basmati, Lordship. As to when she got married with the accused Renush Basmati, I recorded the statement of Milita Basmati on 2/4/15. Milita Basmati told me that on the very day when the laborer stored the ganja in the house premises of Milita, it was recovered on the very same day. On that day, I was with the police, Lordship. Police have already picked me up. As per FIR, the ganja was recovered in the house of Samiran Basmati. I have not recorded my evidence regarding the matter that Pradeep Jha used to finance in the trafficking of ganja. Case diary is silent about Narcotics Control Bureau Office of Calcutta. In Exhibit 5 and 6, GDE should have been recorded as 10 dated 1/4/15 instead of GDE number 11 dated 1/4/15. I did not make any inquiry as to the occupants other than Renush Basmati in the house of Samiran Basmati. The original authority letter empowering SI Montu Deka to take up the investigation and recovered the MDPA substance in connection with Madhbat PS case number dated so and so is not found neither in the case diary nor with the document attached with the charge sheet. So there is no authorization also. The tank shown in the sketch map partly covered. Nature of packets mentioned in the serial list exhibit 5 is not mentioned therein. I did not record the statement of the village headmen or VDP members I recorded the statement of neighboring people of the place of occurrence. I did not record the statement of Samiran Basumatari. It is not a fact that samples were not sent in accordance with the provision of NDPS. I did not record any statement of the revenue staff regarding the land of the place of occurrence. It is not a fact that the LL Ganja was not recovered from any of the accused person and they have been falsely implicated. So this is the evidence in totality. I have already read, Lordship. Now, Lordship, kindly come to 313 of Pradeep Kumar Jha, the appellant. Lord, I will take your Lordship to page number 52 directly. Answer to question number 3, for which I am saying that it is absolutely involuntary. This statement made. 3 to 4%
Page? 53.
52, Lordship, 52. Answer to question number 3.
Page 51.
Oh, I'm sorry, Lordship. Our it's
No, no, yes.
Huh?
And 2 times they were examining the case.
no. This is 313.
That is new.
This is Minush. This is Pradeep.
51.
Pradeep, sir.
52.
Yes. 3 to 4 persons in plain clothes pulled me away from my house. After crossing some distance, they told me that there was a godown used for storing ganja in my bricklin. He has a bricklin, Lordship. And when they forcefully put me in a vehicle, I found police there. It is false that I have confessed before them. So Lordship has kindly got it, Lordship. Then again, page 55, Lordship. Answer to question number 14. Do you have anything to say? Now you will say what has actually happened. The NCB officials picked me up from my house. They told me that I had a godown for storing bhang at my bricklin. But instead of taking me towards my bricklin, they took me towards the opposite direction. That is towards Dhanasri Tea Estate. As we crossed about 1 kilometer, I told them that my bricklin is not situated in that direction. That is why I'm over and over saying that it is not voluntary. His statements are not voluntary. But they told me that I had a godown for storing bhang towards the side of Dhanasri. They took me inside the jungle and showed me bhang from a distance. The NCB officials and the police personnel present there assaulted me and told me to confess. I did not confess. Thereafter, I was taken to police station. I saw Renush at the PS and I could recognize him in the court itself. I am absolutely innocent. This case has been lost against me on false grounds. Now, Lordship, so far as voluntariness is concerned, I am relying upon one judgment, Lordship.
Section
27, I'm cutting 27 now first. 27 of the Evidence Act. Because otherwise, there is nothing against me. That is-
Yes,
Page number 3, Lordship.
yes.
1, 2, 3.
The 4th paragraph. It starts from true. So, Lordship,
True, yes.
kindly find it, Lordship. True such information is admissible in evidence under section 27 of the Evidence Act, but admissibility alone would not render the evidence pertaining to the above information reliable. While testing the reliability of such evidence, the court has to see whether it was voluntarily stated by the accused. Here I am, Lordship.
Yeah, paragraph for that.
Wait a minute.
Oh, okay.
So my submission before Lordship, that absolutely involuntary statement. They picked me up, interrogated me.
What is the citation? No citation.
Yes, Lordship. Yes. No, sorry. It is Rami alias. Then I will come back with SSC.
It is
SSC or,
Yes, Kanun.
yes.
What is the case number? Case number also not clear.
Case number is
Only case name is there.
yes. Then let me come back, Lordship, on 17, along with the citations and all. This judgment itself I will rely, Lordship.
Can take out the. Here, we can come right there.
Right.
From Manu Batra.
Oh, Lordship.
I think we'll have to adjourn if you can't, you see, the thing is that my sister will not be here next week.
All right, we'll let us come immediately after puja, Lordship,
She won't be here immediately after the puja also.
as per the convenience of this purpose.
So probably there'll be a new bench.
Tomorrow or day after, if you can stay back.
Tomorrow is very difficult. Already.
So-
problems are going on.
So next week, he won't be here. So we have to have a fresh hearing again next week.
Actually, it can be make a part head matter.
No, how? When will my sister come again? That is another problem. I will be here.
Friday, can we do it? Lordship, if your Lordship can fix it on Friday.
This is citation is 99-8 FCC, 649,
1999,
8 FCC,
8 SSS.
8 FCC,
649.
6 for Kara, which Kara is it?
This is again mine is Manupatra. But
We are
true, that true
True
thing is
such
paragraph 12,
No.
true such
I will
information.
come back with a citation, Lordship.
Anyway, what we'll do is.
They have the book, I
Okay, we'll just adjourn the matter. We'll adjourn the matter.
Friday, if it can be
Friday
taken,
list
then
has not come
I'll leave
out.
it up to your Lordship. But if it can be taken on Friday. Because I won't take much time. I'm already done.
Anna.
Another 2-3 judgments, that's all.
99.
One judgment, or else Lordship may conclude my hearing. I have got one judgment of your Lordship. One judgment of your Lordship, I'm relying upon them.
This is paragraph 12 only. It will give you. This is paragraph 12 only.
This one,
Ramni.
Lordship, I am on page 6, para 13.
It will be
No, dear, sir, one second.
GLT referral.
আমার হাইতে দেবো, আমার হাইতে দেবো। This is regarding the presumption of possession. Presumption of possession.
No problem. Full paragraph?
13.
The breaking up, no? Slightly different context.
Thank you. Lordship, my submission before Lordship, that nothing has been recovered from us. There is no materials to show that there was a constructive or conscious possession. In fact, the court below tried to rope me in 27 only. In 27, I am showing from the record. The 27 here is not made voluntary. Because he was earlier picked up, Lordship, interrogated into the police station. Then he was taken to the place where already these contrabands were there. And he has said in his 13 statement that I was first asked to show my brick mill. I was going towards my brick mill. They said, no, you go towards that. That means I was
But
forcefully
now
taken. in.
this is on 313.
Yes, Lordship.
It was not put by the defense, but
No, may not be.
in the cross.
What was the statement given by you to the police? Did you give any statement?
No. He said that he has not given any statement. It might be available on the record, Lordship. It's not with us.
Even
Maybe in the-
non-recording of statement will not be fatal always, 27 recovery. If we can show from the other evidence that in fact the information was given by him.
No, there is, in fact, Lordship, in fact, there is no other evidence to show that statement was given by him. Otherwise also, Lordship, supposing I forget about 27, supposing for a moment of time. Here, Lordship will kindly see that the recovery itself is not proved. They have taken up 3 witnesses in the seizure memo. 2 witnesses they could not produce. 1 witness they are relying, who is giving a contradictory statement. And he was from a police personnel. He is giving a contradictory statement altogether. So therefore, the recovery itself is not true. In NDPS case, Lordship, recovery.
No, NDNP's case or any other case doesn't matter. Recovery, the law on recovery would be the same.
Same.
It's only with regard to the provisions of the NDNPS Act. From them.
No,
That requires that it has to be followed.
my very humble submission before Lordship, that so far as my little understanding regarding the NDPS Act, I don't say that I know a lot about NDPS Act, I know very little. I can be punished if I deal with the contraband in any manner. Here, there is no evidence to show.
Not
that
if
I have-
if it can be proved that you deal in it.
Absolutely. Now, Lordship, here is no evidence to show that I have at any point of time dealt with this contraband, this seized contraband. Either directly or indirectly.
No, so that is what we are going to see. Whether the discovery or the recovery of the same was due to you leading them to it or not.
Now,
So we will see. Let us hear the other side.
that is open to the Honorable Court. Now, my submission.
No, it's
before Lordship-
not open to us, it's open to everybody.
Now, my submission before Lordship, to the records which are available with us, the records very clearly shows that any statement made by him was absolutely not voluntary. And that is why I am relying upon the judgment from 1999. So I submit before Lordship that here is a case where this appellant is entitled for an acquittal. And he is languishing there 991 days, if my counting is correct. Lordship. Because earlier, during arrest, he was there for 1.5 years. Thereafter, from the date of conviction, he is inside. And Honorable High Court has given him interim bail, considering his medical ground for limited period, 1 month, 15 days, 3 times. Apart from this, he is inside. 991 days, Lordship, I can be able to look into that. That's all. Otherwise, also, Lordship, my humble submission not being involved also.
Let us see.
It seems that he has finished, so tomorrow I can reply. Lordship,
my
because
university to
file I got it in the morning. Last night I couldn't go through. It was in fact with Miss Bhuya. So I got it in the
No,
morning. So let,
I want both of you to be there. No, otherwise
Ah.
doesn't, is a disconnect. He might want to rebut also while you are arguing. You see, otherwise then we get a two-sided
Hmm.
picture. Otherwise, if I hear you without your presence,
Hmm.
and similarly, if I hear you without your presence, then you might not be able to rebut some of the things that she might say. So that is why I want the presence.
So we'll
Friday, if possible.
adding just one line, Lordship, adding just one line. It appears from the prosecution records that prosecution has tried to build this case only on basis of 161 statements.
Oh, that is not permissible.
no.
That I'm
No,
not.
no, that is a different issue.
I'm just-
Whether they try to build their case or anything, why not?
No.
If
Why,
it is-
why am I arguing, Lordship?
Ah.
I have a reason for that.
Ah.
Because those witnesses, they have been testified before the trial court. And before the trial court, they did not stand by the prosecution case. They have all given a contradictory statement.
Usually happens when these big time drug dealers are involved.
I am absolutely innocent, Lordship.
That's one way of looking at it.
I am absolutely
They've
innocent.
got a lot of money
Hmm.
and a lot of persuasive power.
But Lordship, I was at that time. Maximum time behind the bar.
Maybe
Doesn't
his
matter,
associates,
doesn't matter.
he'll have his associates
You
also.
see, you see a lot of these stories that's coming out with regard to a lot of crime. Number of them are, planned behind the bar.
Yeah, I'm not. Here I am on the record, Lordship. The
Yeah,
record,
yes, no, whatever it is, what we are discussing is just out of, just like that. We have got to decide on the basis of evidence. But the reality is that the big fish are hardly caught. It's only the
Yes.
small fry
Mm.
who have got to, do the foot soldiers work. They are the ones who are caught. The big fish are never caught. Hardly ever, hardly ever. And very difficult. How did ephedrine and all come about? Ephedrine,
Mm.
now it's a controlled substance. Earlier it was never a controlled substance. They used to they make cough syrup.
Mm.
You make a cold tablets with that. And they used to say in the factories in North India, they used to sell it for 1,500 rupees a kg. Across the border, they can sell for 4,500 rupees a kg. Transportation not a problem because it was not an illegal drug or illegal. It was used, it was a salt
Mm.
for manufacture of something. Nothing illegal about it. But once it crosses the border, it's made into amphetamine, methamphetamine.
Mm.
So that is the illicit use. So imagine the killing they used to make by legally transporting
Mm.
or exporting these stuff. There was no illegality.
Mm.
Illegality came about sometime only in the year 2000.
Yes, now it is a banned substance under
Earlier,
the drugs
earlier,
and cosmetic.
earlier truckloads used to go. Truckloads. And imagine in one truckload, the 30-ton
Mm.
truck, 30-ton load. How many kgs? 30,000? 30,000 into 3,000 profit. How much? In one truck, how much money they make?
Mm.
They're also only for the raw material,
Mm.
not the finished product. The finished product comes back in
Yes,
this way. Raw product goes out.
then this methamphetamine comes inside.
Anyway,
Anything
so
is possible.
those big fellows were never,
Mm.
never. It's only
Ultimately-
those persons who come with the tablets and all the stuff, finished product.
Yes, sub-sellers,
That's it.
they get caught.
I remember one case where they got green and blue tablets.
Mm.
The tablets that were sent for FSL were orange and
No,
some other color, brown or something.
happens.
Happens.
Even the facsimile thing also get changed sometimes.
But then the court has to follow the
Mm.
evidence before it. It cannot, make up its
Own
make up a
case.
story on it.
Uh,
So
Cannot
that
fish
way,
also.
so that way, maybe you have a tough task, but that thing might not have. I don't know.
Mm.
We'll hear you first and we'll decide. But I'm just saying that the big fish are hardly ever caught.
that's true, Lordship. Absolutely.
The 360 billion industry,
Mm.
that's the biggest crime, money making business in the world. Number 2 is arms.
Mm.
Anyway, chalo.
Spoiling the entire society. Many many homes are spoiled.
What to do? What to do? All these a lot of underground outfits also.
Mm.
They
Because
did
of
this
money,
to make money.
money only.
That is the money, so that they're going to finance their cause
Mm.
and look after the kitchen of the cadets. They do in the, they do all. At least that is one theory that's going around. Anyway, so
Friday
will.
I'll reply.
But
I could have
for-
replied it today, but then things will be very at the periphery. I won't be able to go to details. So let me go through Friday. I'll make my reply.
Okay, right.
Do we talk about Friday or not? Oh. Oh, yeah. Friday he'll be here.
That's why he said Thursday is not free.
Hmm.
So we'll try Friday. If it cannot be done, then we'll attend the matter.
No, it will be a very short reply and need not take hours and hours. Take maybe half an hour I can finish.
So it whatever will be happening.
Yes. Entire responsibility ultimately is on your lordship.
Yeah, yeah. Both of us, yeah. Heard, Mr.
A Bhattacharya.
Learned Counsel for the appellate. And Ms. S. Jahan, additional people. The appellant has put to challenge the judgment dated 26/11/2020 passed by the special judge Udalguri in special bracket NDPS right close case number 20/2015, by which the appellant has been convicted under section 20B2C NDPS Act, along with co-accused Rinush Basumatari. They have accordingly been sentenced to undergo rigorous imprisonment for a period of 15 years each. And with a fine of rupees 15 years, with
Yes, Lordship.
a fine of rupees 1 lakh each,
1 lakh.
comma, in default to undergo simple imprisonment for 6 months. The prosecution story in brief. No, let's say the prosecution the prosecution story in brief is that. No, don't say that. Don't say, just say the learned trial court has found the appellant herein and co-accused Rinush Basumatari guilty of having committed the offense under section 20B2C NDPS Act, 1985. In view of the fact that 660 kgs of ganja, correct?
Yes, Lordship.
Ganja had been recovered from a what?
It is a underground water tank they are saying.
From a
Water tank.
underground water
No,
tank.
not underground, not a water tank.
From it is under the ground.
Yes.
It was under the ground. No,
They said it's a secret, what? Not secret chamber. Look, they said tank only, tank,
from a water tank,
water tank,
from an empty water tank,
water tank. That is
which
correct.
was behind the house occupied by the co-accused.
Dinesh Basumatari.
Full stop. The land on which the house and the water tank was standing on was, however, in the name of
Samiran, his
another
father.
person, that is,
Samiran Basumatari.
how do you spell his name?
Father. Samiran.
SAMIRAN
R-A-N.
Basumatari.
Samiran Basumatari.
Father of
Who is the
Father
Father of Dinesh Basumatari.
who is the father of the co-accused Rinush
Rinush.
Basumatari? The present appellant has been convicted on the ground that he had led the police and the NCB party to the empty water tank where the ganja had been recovered. First paragraph. Next paragraph. The learned counsel for the appellant submits that the a discovery of the drugs has not been done on the basis of any voluntary statement made by the appellant, as required under section 27 of the Indian Evidence Act, 1872. As such, the appellant could not have been connected with the discovery of the drugs, recovery and discovery of the drugs, as he had not told the police or led them to the place where the drug was allegedly hidden. Correct? Okay. Next paragraph. The learned counsel for the appellant further submits that the evidence of the executing officer, what is it?
Yes,
Huh?
executive officer, Lordship.
Executing officer who
Page number 40.
who was a constable in Masbat police station is to the effect that he had been instructed to serve summons upon Shri Gaira Basumatari, Gaira Basumatari, and Leela Basumatari, Lila, who were seizure witnesses. However, the local public and the village headman told him that no persons by the above name were residing in the village as per the address of the said Caesar witnesses. He accordingly submits that the above casts a doubt on the authenticity of the Caesar memo. As the Caesar witnesses could not be found. Next paragraph. The learned counsel for the appellant has also stated that, also submitted that PW 1, 2, and 3 have been declared hostile witnesses
Lordship.
without following the procedure for declaring an hostile witness as required under section 154
154 evidence.
/ 155 of the Indian Evidence Act. He also submits
Lordship, it will be 154. Yes,
155 and
154 impeachment.
154 or 145.
which one?
It will be 154, Lordship.
154, 155 you cut.
155. Yeah, 155.
He also submits that the evidence of PW8, who is the NCB, what, NCB?
Intelligence officer, NCP, Lordship.
Who is the intelligence officer, NCB? Implies that the place of recovery of the drugs had been shown to the police by an informer and not by the appellant. Is that correct?
Yes, Lordship.
That's all. I think anything else?
That's all. I have also submitted regarding the veracity of the statement made by TW7. TW7 was also a Caesar witness, Lordship.
So
He also did not support the Caesar.
what did he say?
Lordship, he said in his first. He said, I do not know what purpose IO has used the sheet of the paper to which I put my signature. I do not know how many packets were prepared. I do not know the weight of the same. I do not know what things were.
He also submits that the evidence of PW7
Seven.
who is another Caesar witness,
Of the same Caesar, Lordship.
does not know anything about the Caesar. Correct?
Lordship.
He submits that in terms of the judgment of the Supreme Court, in the case of Rammi alias Rameshwar, RAMMI, alias Rameshwar versus State of Madhya Pradesh, 1999, 8 SCC 649. The court, while testing the reliability of the evidence pertaining to section 27 of the Evidence Act, has to see whether the same was voluntarily stated by the accused. In the present case, the statement was not voluntarily stated by the accused. Why not voluntarily stated?
Past he was.
In view of his explanation given during his examination and the section 31 PCRPC. And the evidence of PW12.
PW, no. Says that he was first picked up, interrogated.
Interrogated.
Yes, no, definitely, yes, sir.
Answer interrogated.
Yes, sir.
No, okay, those are the fact that those. Whatever I said, just read it.
PW6. PW6 Lordship, the informant.
The learned trial court could not have come to a finding that the appellant had made a statement, voluntary statement leading to the recovery of the drugs. Next paragraph. Ms. Eljahan, additional PP, says that the matter may be listed on Friday to enable her to give her submissions on the set date. Prayers allowed. This is the matter of Friday. That's all, I think.
Keep looking.
Friday, Mr. Kamar's matter is there, but I
Oh, yes, Kamal matter is there. That is, there are two of them, in fact.
I'll have a short reply. Mr. Kamar might be taking long, but then my matter can be taken up first.
We have heard him also a little bit.
Lordship will sort out.
Just thinking what happened to our weekend.
Lordship will dictate it here. Of life.
Keep looking.
There, right.
Okay, he's looking in. Okay, go ahead. Go ahead.
There are 13:10.
13 date to lower visa nasa.
Huh?
13 date to lower visa nasa. Unlucky 13. So we go.
तुम्ही हेडना ओला किंवा
आपके मुंह में भी सकता है. आपके मुंह में भी सकता है.
हाँ
आपका ये तो छोटी सी है.